So recently, the General Overseer of Omega Power Ministries came out publicly to announce that he was looking for a wife for his adopted son. The adopted son in question is a non-verbal autistic child, but that's not all. He went further to make mouth-watering promises to anybody who was able to accept such an offer. Some of those benefits included a house, a cash gift of 10 million naira, an all expense paid foreign vacation, and so many other incentives. And as a result of that, a woman in her 50s, a single mother of three in her 50s, accepted the offer. And just last week, Sunday, so this marriage in question has sparked up a serious public outrage, and people have questioned the validity of such a marriage under the Nigerian laws. And that's the reason why I decided to make this video to discuss and explain the validity of a marriage. Welcome everyone once again to Alpha Pisces Legal Series, where we explain and simplify the law to help you with your daily life. So in case you don't know, my name is Dr. Barbara Uchechukwu Abayomi. I'm a legal practitioner, a family law expert, a notary public, and an educator. My purpose here is to break down the complex legal issues to help you understand your rights and to make the law practical and relatable to your everyday life. So if you're interested in videos like this, all you need to do is click on the subscription button, like this video, and turn on your notification bell so you don't miss out on other legal insights. So let's delve into the crux of today's matter: validity of marriage under the Nigerian. So before we proceed, I would like to make it clear that the whole essence of this video is not to attack anyone. Or rather, the essence of this video is just to educate the public on what the law says about marriage. So it's important to note that the statutory marriage in Nigeria is governed by two laws. One is the Marriage Act and the other is the Matrimonial Causes Act. These two laws are the laws that govern statutory marriages in Nigeria. While the Marriage Act governs how a marriage should be conducted in Nigeria, the Matrimonial Causes Act governs on issues after the solemnization of a marriage. It talks about whether that marriage that was conducted, whether it is valid or a nullity. It talks about other issues like the dissolution of marriage, maintenance of spouses, and all that. But for the purpose of this video, we will restrict ourselves to the validity of a marriage under the Matrimonial Causes Act. Section 3 of the Matrimonial Causes Act provides that for a marriage to be valid, both parties must have a mental knowledge, they must have an understanding of the nature of a marriage and the duties and responsibilities involved. So for a marriage to be valid, both parties must have an understanding, must understand what they are going into. Marriage is a contract. So for you to take up, for you to partake in that contract, for you to be a party to that contract, you must have an understanding of what that contract entails. So it's not enough to just be aware that something is happening. No, you must have the knowledge, you must have the understanding of what it entails. There are several cases where the court has also stated that a marriage where a party does not have an understanding of what it entails cannot be said to be a valid marriage. So now let's look at this situation. Let's look at this marriage, this this situation we are analyzing. The young man in question, he's an autistic young man, a non-verbal autistic young man. The question is, can an autistic person understand the duties, the responsibilities that is ascribed to him in a marriage? That's the question. For me, I would say no. He does not understand it. He doesn't even know what he's going into. He lacks understanding of it, sorry to say. He doesn't understand that he's getting married. He doesn't know the duties placed on him as a father. He doesn't know the duties placed on him. He doesn't know the responsibilities placed on him as a husband. He doesn't know that this is what he's meant to do, what he's not meant to do. He doesn't have that understanding. So at this point, do we now say such a marriage is valid? The answer is no. It's not valid based on this requirement, based on the provision of the law. If you don't have a mental on the knowledge of what you're going into, if they cannot call you and you cannot explain that, oh, I fully understand that this is what is required of me in this marriage and all that, then you cannot say you that such a. Now, this is the reason why under the Nigerian law, for you to go into a marriage contract, you must be of legal age. You must be an adult. Reason being that there is a presumption that an adult understands what a marriage is all about. An adult understands the nature of a marriage. An adult understands what is required of him, the duties, the responsibilities that are required of him when going into a marriage. So, except it can be proven that he has the capacity to understand, except there is a proof that he truly understands the nature and the duties, responsibilities that are required of him in that marriage. If it can be proven that yes, he understands such responsibilities, then okay, we can say the marriage is valid. But where he has no mental knowledge, where he has no understanding of the nature of the marriage, where he has no understanding of what he's going into, then truthfully, such a marriage cannot be said to be valid under the matrimonial laws, especially as provided under Section 3 of the Matrimonial Causes Act. Then also, another requirement for a marriage to be valid under the Nigerian laws by virtue of Section 3 of the Matrimonial Causes Act is that consent of both parties must be given. And that consent must be freely given. Consent must be freely given. Consent must not be induced. Consent must not be given by reason of duress. Consent must not be given by reason of inducement. No, it must be freely given. There have been several cases where the court has held that a consent that was obtained by duress, a consent that was forcefully given, a consent that was obtained by enticement, when you entice somebody and make a person give consent, such a consent cannot be said to be freely given. And where a consent is not freely given, the person goes into a marriage, such a marriage cannot be valid. So now the question is, was the consent of the young woman freely given? Was such a consent not as a result of the benefits attached to the offer? Without those benefits, would the woman have accepted such an offer? That's the question. Was that consent by the woman not as a result of, was it not given by inducement? If the answer is yes, then such a marriage cannot be said to be valid under Section 3 of the Matrimonial Causes Act, because the law is clear that the consent must be freely given. A consent, an offer that was made out with lots of mouth-watering benefits, and then looking at the woman that accepted just few days after the offer was made, the woman in question is almost double the age of the young man. The woman is a single mother with 3 children. So looking at the circumstances surrounding this situation, can we truly say that the consent of that woman was given freely? That's the question. For me, my answer is no. For me, I would say the consent of the woman was given by inducement. For me, I would say such a consent was not freely given, because if those benefits were not attached to that offer, that young woman wouldn't have accepted the marriage offer. she wouldn't have done accepted. That's me. That's my own opinion. Your own opinion can be different. But for me, my opinion is this. A marriage offer shouldn't come with such mouth-watering benefits, especially in such circumstances, so that anybody accepting to go into such a marriage will accept it without being induced by any external forces. So if it was a situation where they had said, okay, we need somebody to marry, and then there was no benefit attached, and the young woman accepted, okay, we would have said, oh, she did it by voluntarily, she did it on her own volition and all that. But looking at the lineup of the incentives attached, personally, I would say her consent was as a result of the benefit, or was as a result of the benefits that were attached to. So under the Matrimonial Causes Act, there are marriages that are void and that are voidable. Void marriages are marriages that never ever existed under the eyes of the law. It means, yes, you might have contracted the marriage, you might have had a marriage ceremony and all that, but under the eyes of the law, such a marriage never ever existed. Example of such marriages are marriages that are contracted in places that are not licensed. For instance, you go to contract a marriage in a church that doesn't have the license to contract a statutory marriage. Such a marriage is void. The law doesn't even see such a marriage. Marriage like that never existed under the eyes of the law. Another example is a marriage contracted where either of the parties lack the mental capacity to contract such a marriage. Where either of the party doesn't have the understanding of the nature of a marriage, or the duties or responsibilities that are required of him in such a marriage. Where such a thing happens, such a marriage is void. Such a marriage never existed in the eyes of the law. It therefore means that whatever was carried out was just a ceremony, yes. In the eyes of the law, both parties are not married. Now, in this situation, if it is fully established that the young man in question lacks mental capacity to go into such a contract, into a marriage contract, then under the eyes of the law, by virtue of Section 3 of the Matrimonial Causes Act, such a marriage never existed. Such a marriage never ever existed. It means what was done that Sunday was just a ceremony, but not a marriage. It therefore means that both parties are just cohabiting. They are just cohabiting. Under the eyes of the law, they are not married. Then, for voidable marriages, there are marriages that, yes, they were void at the time when they were conducted. But then, probably subsequently, there were some factors that were established to show that this marriage was not proper. Such a marriage can be declared voidable by the courts. What I mean is this. Where, for instance, where a consent was not freely given and the marriage was conducted, yes, the marriage might have been conducted properly in a licensed place and what have you. But where it can be established that the consent of the person going into the marriage was not freely given, maybe it was given by inducement, maybe it was given by duress, maybe it was given by whatever reason. Once such a thing can be established, then such a marriage is voidable. The court can cancel such a marriage. Now, looking at this current situation, once it is established that the consent given by the woman in question to accept the offer of marriage was not freely given, probably it was given by inducement as a result of the benefits that were attached to the offer. Once it can be freely established, once it can be fully established, then such a marriage is voidable. The court can cancel such a marriage. So now let's bring these two factors that we've established together. The question now is, such a marriage, this marriage conducted by the Omega Power Ministries general overseer in his church on Sunday for his adopted son. The question is, can such a marriage be said to be valid under the eyes of the Nigerian law? While I'm not here to criticize anybody, while I'm not here to talk down on whatever decision that was taken in the church, but looking at what the provisions of the law has said with regards to Section 3 of the Matrimonial Causes Act, personally, I would say such a marriage is not valid under the Nigerian laws. Reason being that, one, the young man in question has no mental capacity of the nature of a marriage, of the marriage contract that he's entering into. He doesn't have the understanding of the duties, the responsibilities required of him as a husband or as a father that he's going to be. He doesn't have the understanding. And where such a thing exists, such a marriage is not valid. Secondly, I am also of the opinion that the consent given by the young woman in question was not freely given. Her consent was as a result of the benefits attached to the marriage offer. And in such a situation, that marriage is voidable and therefore not a valid marriage under the laws of. So it is important for us to know that as a society, not everything that happens in the church or that happens in the mosques automatically makes it become valid under the eyes of the law. No. If the law has been specific and has provided for something to be valid and such a thing is not followed, nothing can make it become valid. No, it must follow what the law says. So if the law has said that for a marriage to be valid, the parties must have mental knowledge and their consent must be given freely. If these two things don't exist in the marriage, then such a marriage cannot be said to be valid. The law is here to prevent exploitation. The law is here to protect the vulnerable. The law is here to prevent manipulation of the vulnerable. That's the reason why the law has stated that before you go into any contract, including marriage, which is a contract, such a person must have a mental understanding of what he's going into, what he's signing, what he's going into. He must have the mental knowledge of such a thing. So if you found this video insightful, if you found this video educative and interesting, kindly like, share, and subscribe to this channel. So thanks for listening. Thanks for staying with us. See you on our next video. Take care and have a nice day. Remember, not every marriage conducted is valid under the eyes of the law in Nigeria. Make sure whatever marriage you're conducting is in line with the requirements of the law. Take care. Bye.